Hey there, neighbors. Just a quick request before we jump into the episode. I've been posting a lot more short form content on places like Instagram and TikTok, and then reposting that stuff to places like Threads and X and Facebook. So if you would, go to the podcast website, www.neighborontheleft.com, and in the contact section, all the social media links are there. Stop on over and check out some of the short form content. It tends to be a bit more lighthearted, at least some of it, more comedic than the heavy podcast episodes. But I would love to have you stop by, and if you'd be so kind to like and follow what you see. Thank you very much. And on to the episode. You have a knife drawer, right? Every house has a knife drawer. And, most of the time it's closed. You know it's there. You know what's inside. You just don't spend a whole lot of time thinking about it. Then somebody pulls it open. And suddenly, you're paying very close attention to what's in the drawer. That is the Supreme Court in June. For most of the year, the court is operating somewhere in the background of American life and thoughts. The cases are moving, the briefs are being filed, the arguments are happening, the justices are reading and debating and drafting and revising and bargaining and probably irritating each other in very polite Latin. And most Americans are not thinking about any of it. Then June arrives, and the drawer slides open, and suddenly everybody wants to know who's getting cut and with which knife. Because Supreme Court decisions don't just affect the lawyers, they affect workers and voters, women, immigrants, religious groups, students, LGBTQ Americans, sometimes presidents, sometimes all of us. And this is the strange thing about the Supreme Court. It doesn't have an army, it doesn't have a police force, it doesn't run campaigns. It doesn't pass legislation. It doesn't hold town halls where everybody, gets to show up and be mad about whatever. But every June, 9 unelected people in black robes can hand down decisions that reshape American life. And this year, some very sharp blades are still sitting in the drawer. Greetings to all, and welcome to Your Neighbor on the Left, a podcast where we talk about progressive politics, human decency, and life on the blue side of America's ideological divide. My name is Don Spielis, and I am your host. And today we're going to be talking about the Supreme Court. This is a very important time of year for the Supreme Court, and maybe in a way that a lot of people don't realize or don't think about. Every year around this time, the Supreme Court sort of becomes unavoidable. And I mean unavoidable in that very specific American way, where a government institution that you probably haven't thought about in months suddenly walks into your living room, kicks over the coffee table, and says, actually, the rules are different now. That's what June can feel like if you're paying attention. Most people don't follow the Supreme Court all that closely during the year. And I get it. Supreme Court coverage is not exactly designed for normal humans. Those of us with jobs and errands and pets and kids and bills and a finite amount of patience for phrases like, procedural posture. That phrase alone sounds like something your chiropractor would warn you about. But the court has a rhythm. It has a calendar. And once you understand the rhythm, June starts to make a lot more sense. The Supreme Court's term begins in October. That is why people who follow the court talk about the October term. The justices hear cases over the fall and winter and spring. Lawyers come before the court and argue. The justices ask questions. Sometimes those questions are sincere. Sometimes they're a little legal fishing. Sometimes there are less questions than tiny speeches, with question marks at the end. Then, after arguments, the justices meet privately. They vote. Someone in the majority gets assigned to write the opinion. Drafts start to circulate. Other justices respond. Some join, some refuse, some write separately. Some say, I agree with the outcome, but not the reasoning. Some say, absolutely not, and I brought footnotes to show you. That is where you get majority opinions, concurring opinions, and dissents. Majority opinion is the ruling of the court. That is the one that controls the outcome. The dissent is when one or more justices say, essentially, no, wrong. I'm writing this down for history and possibly for future law students who enjoy suffering. A concurrence is a little more complicated, but in plain English, it usually means I agree with the result, but I got there in a different way. So these decisions take time. They're not just handed down the day of the argument. Opinions are drafted, revised, negotiated, sharpened, softened, sometimes expanded, sometimes narrowed. Votes can shift. Language matters. One sentence can change how lower courts apply a ruling for years to come. And that is why so many big decisions arrive near the end of the term. By June, the court is running out of runway. The easy cases, the unanimous cases, the less explosive cases, those often come earlier. But the biggest ones, the ones with the most disagreement, the ones where every word is being fought over, like the last parking spot at Walmart, those tend to pile up. So June becomes Supreme Court season, if you will. It becomes the month where reporters refresh the court's website like they're waiting for concert tickets. It becomes the month when legal analysts start, trying to read the tea leaves in opinion release schedules. It becomes a month where people who have not said the words separation of powers since high school suddenly find themselves asking, wait a minute, can they do that? And the answer is most often yes, they can do quite a lot. And that is the part that we need to sit with. Because the Supreme Court is not just another government body. It's not some, dusty museum where constitutional scholars go to whisper. The court routinely decides questions that affect millions of people. Sometimes those questions are obvious. Can states ban certain medical procedures? Can the government restrict speech? Can police use certain kinds of evidence? Can states draw voting maps in a certain way? Can a president do something Congress never clearly approved? But sometimes the questions sound technical until you realize the consequences are enormous. A case about administrative agencies can affect clean air rules and workplace safety, medication approval, protections for consumers, and, like whether experts in government are allowed to do the thing that they were hired to do. A case about standing, procedure, jurisdiction, or statutory interpretation may sound like legal mumbo jumbo, but buried inside that can be the future of environmental regulations or civil rights enforcement or immigration policy or even access to the courts themselves. That is one of the reasons the Supreme Court can be so difficult to talk about, because the language is often really boring, but the stakes are not. The court speaks in citations and doctrines and standards and clauses and precedent, but the results, those land in hospitals and schools and workplaces and polling places, bedrooms, border crossings, prisons, churches, city halls, kitchen tables. The list goes on. That is why June matters. Not because legal nerds need a Super Bowl, although they do seem to enjoy having one. June matters because this is when the quiet machinery becomes visible. This is when months of argument and drafting turn into actual rulings. This is where that drawer opens. And once it opens, people start realizing sometimes something uncomfortable. A lot of American life can be changed by people we do not elect, cannot vote out, and may not even be able to name for some folks. That does not automatically mean the court is illegitimate. Of course not. It does not mean that every ruling is political. It doesn't mean that justices, are some sort of cartoon villains, but it does mean we should understand the power that we're talking about. Because if 9 people can change life for hundreds of millions of Americans, a reasonable question follows. How did they get that much power? So, if you actually open the Constitution and read Article 3, which is the part that creates the federal judiciary, it doesn't exactly come with a glowing instruction manual that says, congratulations, Supreme Court, you are now the final boss of American government. Article 3 establishes the judicial branch. It creates one Supreme Court. It allows Congress to create lower federal courts. It says judges hold their offices during good behavior, which basically means they're appointed for life unless they resign, retire, die, or do something so outrageous that Congress actually manages to agree on impeachment, which is not exactly America's most common group project. It gives federal courts power over certain kinds of cases and controversies, but it does not clearly spell out the one thing most Americans now associate with the Supreme Court: the power to strike down laws as unconstitutional. That power is called judicial review, and judicial review is the reason the Supreme Court can look at something passed by Congress, signed by the president, supported by any number of millions of voters, and say, nope, that violates the Constitution. And that is enormous power, and it comes, famously, from an 1803 case called Marbury versus Madison. Now, listen, I promise we're not going to spend a whole ton of time here wandering around 1803 like we got lost on the way to the Hamilton show, but we do need the basic story. At the end of John Adams' presidency, Adams and the Federalists were trying to place their people into government positions before Thomas Jefferson took over. One of those people was William Marbury. He had been appointed as Justice of the Peace, but his official paperwork, his commission, did not get delivered before Jefferson became president. Jefferson's Secretary of State, James Madison, refused to deliver it. So Marbury went to the Supreme Court and said, essentially, make Madison give me my commission. Chief Justice John Marshall had a problem. If the court ordered Madison to deliver the commission and the Jefferson administration ignored the court, the Supreme Court would look weak. But if the court simply backed down, then it would also look weak. So Marshall did something very clever. He said Marbury had a right to the commission. He said Madison should have delivered it. But he also said the Supreme Court did not have the authority to issue the kind of order Marbury wanted because the law giving the court that power conflicted with the Constitution. In other words, Marshall told Marbury, you're right, but we can't help you. And in that process, he declared that it is the role of the judiciary to say what the law is. That is the famous piece. That is the birth, or at least the formal announcement, of this judicial review in American constitutional law. And that one moved everything. Because once the Supreme Court claims the authority to decide whether laws violate the Constitution, it's no longer just resolving disputes between parties. It becomes the institution that can tell the other branches, you've gone too far. Now, in theory, that can be a good thing. We do not want Congress to pass unconstitutional laws just because they're popular for whatever reason. We don't want presidents to ignore constitutional limits just because their supporters, enjoy the show. And we don't want majority rule to become majority power with no guardrails at all. A constitutional democracy needs limits. rights aren't supposed to vanish just because the wrong political mood happens to take over. So the court can serve an important role. It can protect rights, it can check abuses, it can stop the government from crushing people just because the people being crushed are unpopular. That's that's the noble version. And sometimes that version is real. But power doesn't stay in civics textbooks. Power lives in the real world. And in the world, the Supreme Court has become much more than a neutral traffic cop blowing a whistle when someone runs through some sort of constitutional red light. Over time, the court has become one of the main places where America's biggest unresolved arguments go to fight in formal wear. Part of that is because Congress has become very, very good at avoiding hard decisions. Not so good at solving them, just good at avoiding them. Congress holds hearings and they issue statements and they go on cable news. Congress will use a problem to raise money. Congress will send emails with subject lines that sound like, the apocalypse is scheduled for Thursday. But actually legislating on the biggest, most divisive issues, that has become apparently harder and harder. So presidents step into the vacuum. They use executive orders, agencies issue rules, states pass conflicting laws, advocacy groups sue when they're not happy with something, lower courts split, and eventually the Supreme Court gets asked to settle the argument. And there we are again, 9 people, lifetime appointments, no elections, they get the final word. This is how most people imagine that democracy works. Most people are taught a very simple version of American government. Congress makes laws, the president enforces the laws, and the courts interpret the laws. It's nice and clean. 3 branches, schoolhouse rock, on and on. But real government is messier, to say the least. Congress often writes vague laws because vague laws are easier to pass. Presidents stretch executive power because, one of the reasons is because Congress is gridlocked. Agencies try to fill the details because modern government is complicated. States push boundaries because state politicians also enjoy cameras and fundraising emails. Then the courts are asked to decide what the hell it all means. And once the Supreme Court decides, that decision can become the practical rule for the entire country. So yes, Congress makes laws, but if Congress writes a law and the court says the law violates the Constitution, the law is gone. And yes, presidents have executive power, but if a president acts and the court says the action is unconstitutional, so much for that action. And yes, states have authority, but if a state policy violates federal constitutional protections, then the court can nix that as well. That is why the Supreme Court is so powerful. It doesn't need to create policy in the normal sense. It can reshape policy by deciding what government is allowed to do, what it's forbidden to do, and what the Constitution requires that it do. And this creates a democratic dilemma. Because federal judges, again, are not elected. Supreme Court justices are appointed by presidents and confirmed by the Senate, but once they are on the court, we voters don't get to remove them because, we dislike rulings. There is no national referendum after a Supreme Court decision. There's no ballot question that says, would you like to renew this justice for another, 6-year term or whatever. They are there for life. Now, that design has a purpose. The idea is that judges should be confident, not terrified of the next election. They should be able to protect constitutional rights, even when doing so is unpopular. They should not have to check polling numbers before ruling that, government violated someone's rights. And that independence is important, very important. But independence and power together can become a very volatile mix. Because if you give unelected judges enormous authority, and then many Americans begin to believe those judges are simply doing politics in their robes, the legitimacy problem starts pretty much immediately. That's the tension. We want courts independent enough to stand up to political pressure, but we also live in a democracy where people are supposed to have some say in the rules that govern their lives. And when the court resolves huge national questions, questions Congress refuses to handle or presidents try to muscle through, people start asking what I think is a very fair question. Who decided that this was the way it had to be? Now, the answer from the legal world is usually something like the Constitution as interpreted through precedent and judicial review, which is accurate. It's also kind of a sentence that makes normal people stare at the wall and wonder, if they left the oven on. Because what they're really asking is simpler. They're asking, why do these 9 people get the last word? And the honest answer is because over time, through history and precedent and institutional habit, sometimes political failure, that is the system we built. Not all at once, not in one dramatic scene with, thunder outside Independence Hall, just slowly, case by case, crisis by crisis. Avoided congressional vote by avoided congressional vote. The court became the place where America sends questions it cannot settle anywhere else. And that means the Supreme Court is not just interpreting the rules of the game. In many moments, it's deciding what game we're even playing. And nowhere is that more obvious than when the court changes the direction of the country. One of the easiest ways to understand the power of the Supreme Court is to stop talking about legal theory for a minute and look at what the court is actually done. Because sometimes we talk about the court as if it's, like an abstract institution. Black robes and marble columns and Latin phrases, a building tourist photograph when they're already in Washington. But the court's real power shows up in the lives of us, the people, afterward. And if you want proof that 9 justices can change the direction of a country, history is overflowing with examples. So I want to talk about some of those. We'll start with one of the most important ones, Brown versus the Board of Education. When people talk about landmark Supreme Court decisions, this is usually right near the top of the list, and for very good reason. Before Brown, racial segregation in public schools was considered constitutional under a doctrine known as separate but equal. The theory was that Black Americans and white Americans could be separated as long as the facilities were supposedly equal. The reality was exactly what you'd expect. They weren't equal, not even close. Schools serving Black children routinely received fewer resources, older materials, worse facilities, less investment. The inequality was painfully obvious, and everyone knew it. The law simply pretended not to notice. Then in 1954, the Supreme Court unanimously ruled that separate educational facilities are inherently unequal. Think about that for a second. One ruling, one decision, and suddenly a legal framework that had shaped American life for decades was no longer considered constitutional. Now, that didn't magically solve the problem of racism. Far from it. The ruling was followed by resistance and obstruction and political backlash, and in some places just outright defiance. But the decision fundamentally changed the legal landscape. It established that the Constitution could not be used to justify state-sponsored segregation in public education. That is the Supreme Court changing America. Then there's Miranda versus Arizona. This is one of those decisions that you know about even if you don't know you know about it. You've heard it in the movies. You've heard it in television shows. You've probably heard some version of it from, fictional police officers on a screen 1,000 times. You have the right to remain silent. That comes from Miranda. Before that ruling, police departments were not required to inform suspects of certain constitutional rights before they were interrogated. The court held that suspects must be informed of their rights under the Fifth Amendment, including the right to remain silent and the right to an attorney. Now, people can debate whether the ruling helped criminals or protected citizens, complicated investigations or strengthened civil liberties, but there is no debate that it changed how law enforcement operates. One Supreme Court decision altered police procedure across the entire country. That is real power. Then, of course, we get to Roe v. Wade. And if there is a legal case that demonstrates both the power and the controversy of the court, it's this one. In 1973, the court ruled that the Constitution protected a woman's right to obtain an abortion under a broader right to privacy. For millions of Americans, Roe represented a major expansion of personal freedom and bodily autonomy. For millions of others, it represented judicial overreach and the protection of a practice that they considered morally wrong. Now, regardless of where someone stood, Roe immediately transformed national politics. It became one of the defining issues in American public life. Presidential elections, Senate races, future judicial confirmations, religious activism, political coalitions, all of them profoundly affected. A single Supreme Court ruling helped reshape the American political landscape for generations. And, think about that for a second. Not Congress, not a constitutional amendment, not a national referendum, a Supreme Court decision. 9 folks. Then there's Obergefell v. Hodges. And for much of American history, same-sex couples could not legally marry. That changed in 2015 when the court ruled that same-sex marriage was protected under the Constitution. And what made Obergefell especially remarkable was how quickly public opinion had shifted leading up to it. A position that had once seemed politically impossible became constitutional law. For LGBTQ Americans, that decision represented recognition and dignity and legal protection and equality under the law. For opponents, it represented judges imposing a social change that should have been decided through democratic processes. Now, you notice something? We're seeing that same argument again, not necessarily over the outcome, but over who gets to decide. That question keeps showing up. And then, of course, we arrive at Dobbs. Dobbs v. Jackson, Women's Health Organization. The 2022 decision that overturned Roe. This is where the knife drawer metaphor starts feeling less like a metaphor and more like a weather forecast. Because regardless of where someone stood on abortion, there was no denying the scale of what happened. A constitutional protection that had existed for nearly 50 years vanished. Authority shifted back to the states. Trigger laws took effect. New restrictions appeared. Legal battles exploded. Political campaigns reorganized themselves pretty much overnight. For conservatives, Dobbs represented a correction of what they viewed as a flawed constitutional ruling. For progressives, it represented the removal of a fundamental right and proof that long-established precedent was no longer secure. And again, I'm not here to relitigate the abortion debate. That's a whole nother topic. But the point I'm trying to make is the magnitude. One Supreme Court ruling changed the legal reality for millions of Americans. That is what power looks like. And those are only 5 examples. You could easily add dozens more. Voting rights, religious liberty, criminal procedure, campaign finance, presidential authority, labor rights, environmental regulation. The list just goes and goes and goes. What matters for our purposes today is the pattern. The Supreme Court is not merely a legal institution that resolves obscure disputes between attorneys. It is one of the primary engines through which American society changes. Sometimes those changes are celebrated. Sometimes they're condemned. Sometimes they're viewed as necessary corrections. Sometimes they're viewed as dangerous mistakes. But they are rarely insignificant. That is why Supreme Court appointments have become so politically important. Nobody spends millions of dollars trying to influence an institution that doesn't matter. Nobody treats judicial vacancies like national emergencies if the court lacks power. The reason confirmation battles have become so intense is because everybody understands what's at stake. Maybe not always consciously, but instinctively. People know these decisions matter. They know they can affect how rights are defined, how laws are enforced, how power is otherwise distributed. And that brings us to the question that sits underneath almost every Supreme Court argument. Not what the Constitution says, but how we're supposed to understand what it says. Because if the court can change America this dramatically, then the method the justices use to interpret the Constitution suddenly seems super important. And that is where things get really interesting, because for generations, Americans have been fighting over a deceptively simple question. How should a document written more than 2 centuries ago govern a country the people who wrote it could have never imagined? And this is where the conversation usually starts to get complicated, and not because the ideas are impossible to grasp, but because lawyers have spent generations finding increasingly sophisticated ways to explain a disagreement that most normal people grasp immediately. The disagreement is this: when the Constitution was written, should its meaning stay fixed? Or should its application evolve as society changes? That's the fight right there. Everything else is details. Now, before anybody starts sharpening knives in the comments section, let's be fair to both sides, because neither argument is crazy. The conservative argument, broadly speaking, is called originalism. And at its core, originalism is actually pretty straightforward. The Constitution means what it meant when it was adopted. Not what judges wish it meant, not what politicians wish it meant, not what the public opinion says it should mean this year. The actual meaning of the text remains the meaning of the text. The originalist concern is simple. If judges can change constitutional meaning whenever society changes, then judges effectively become lawmakers. And if judges become lawmakers, then why have a legislature at all? Which, is a question I've asked a lot lately. But from that perspective, a constitution that means whatever modern judges want it to mean is not really a constitution. That's their argument. It's a suggestion box. And honestly, it's not a totally irrational fear. Constitutions are supposed to create limits. If every generation can simply redefine the limits, eventually there are no limits at all. Now let's look at the other side. The living Constitution approach starts from a different concern. Its supporters generally agree that the constitutional principles matter. They agree the text matters. What they question is whether the people living in the 21st century can simply freeze constitutional understanding at the moment a document was written in the 18th century. The country has changed dramatically. The economy changed, technology changed, medicine changed, communication, human understanding. The world has changed, and the Constitution remains. The living constitutionalist argument is that the Constitution contains enduring principles rather than permanently frozen applications. Equal protection, due process, freedom of speech, protection against unreasonable searches. Those principles remain constant. The application evolves. And honestly, whether people realize it or not, most Americans already accept some version of this idea. Here's a simple test. The founders knew about newspapers. They knew about pamphlets. They knew about public speeches. They knew about angry letters that could be written. The founding generation practically invented writing angry letters. What they did not know was about the internet. They didn't know about TikTok or Facebook or podcasts. They didn't know about AI generated content. They did not know about social media platforms capable of reaching hundreds of millions of people in seconds. So when we talk about free speech online, what exactly are we doing? The First Amendment doesn't mention websites. It doesn't mention algorithms or servers or digital platforms. Yes, everybody agrees the First Amendment applies. The disagreement is how. The same thing happens with the Fourth Amendment. The founders knew what a search was. A government official enters your property. They look through your things. Pretty simple. What they didn't have a clue about were smartphones or GPS tracking or cell tower data or facial recognition software, mass digital surveillance, DNA databases, cloud storage. So when the government can reconstruct years of your movements from data collected by a device in your pocket, what does the Fourth Amendment require? The Constitution doesn't explicitly answer that question. Judges have to answer it every single time. And this is where the debate becomes really interesting. Because even judges who reject the idea of a living constitution still have to apply 18th century language to 21st century realities. There's no way around it. Nobody can ask James Madison what he thought about artificial intelligence. You can't call up Alexander Hamilton and get his position on social media moderation. The founding fathers can't be queried as to, whether a smartphone should be treated like a filing cabinet, a diary, or a mailbox, or something entirely new. Eventually, every judge has to make judgment calls. The disagreement is over how much flexibility those judges should involve. Now, here's where things get particularly relevant to the modern court. For decades, conservatives generally position themselves as defenders of fixed constitutional meaning. Progressives were often accused of treating the Constitution as a living document. Conservatives would respond that judges should not update constitutional meaning simply because society changes. That was the battle line for years. Then something interesting started happening. Increasingly, critics began arguing that conservatives themselves were embracing constitutional interpretations that would have seemed radical a generation earlier. Not necessarily because conservatives saw it that way. They would argue they were restoring original meaning. But critics see something different. Take presidential power, for instance. Many constitutional scholars today are debating theories of executive authority that would have generated far less attention a few decades ago. Questions about how much authority a president actually possesses, questions about the limits of executive action, questions about immunity, questions about whether certain checks on presidential power are unconstitutional. And these aren't small questions. They are questions about the structure of American government itself. Then there are challenges to the administrative state. Now, administrative state sounds like something people complain about at conferences, where everybody has their own copy of the Constitution. But in practice, we're talking about agencies. The people who regulate air quality and food safety and workplace standards and, drug approvals, environmental rules. For decades, agencies were given, often, significant deference by courts when interpreting laws within their area of expertise. Recently, that deference has come under increasing scrutiny. Supporters say this restores constitutional accountability. Critics say it shifts enormous power towards the courts and away from experts. Again, same Constitution, different interpretations. And then there are discussions surrounding birthright citizenship. Discussions about long-established precedents. Discussions about doctrines that, I would say the average American just assumed were settled. What makes these debates fascinating is that, both sides often point the finger at the other and say they're doing the exact same thing. Progressives accuse conservatives of discovering new constitutional meanings that conveniently align with their modern conservative priorities. Conservatives accuse progressives of reading modern values into a document that never contained them. Each side insists it's defending the Constitution, and each side believes the other side is rewriting it. And maybe that is the part of why this debate is never ending. Because at a certain point, the argument isn't about specific clauses anymore. It becomes an argument about what constitutional interpretation itself should look like. And here's a question that keeps nagging me. If the Constitution's practical meaning today differs from what most Americans thought it meant 20 years ago, why is that? Is it because judges are finally returning to the original meaning, or is it because different groups of judges are now doing the interpreting? That question sits underneath so much of our political conflict these days, and no matter how somebody answers it, one thing seems clear. Every justice claims to be following the Constitution. Every one of them. No justice walks into the court and announces, "Good morning, I plan to ignore the Constitution entirely today." That's just simply not how it works. The disagreement is over what faithful interpretation actually means. And once people begin believing that constitutional interpretation is really just politics wearing legal robes, another problem starts to emerge. And I think it's a much bigger problem, because now we're not arguing about constitutional clauses anymore. Now we're arguing about trust. And once trust enters the conversation, legitimacy and doubting it isn't far behind. Legitimacy is a strange kind of power because you cannot command it into existence. You cannot pass a law requiring that people trust you. You can't issue a ruling that says the public shall hereby believe we are neutral. You can't put a robe on and automatically become respected. Legitimacy has to be earned. And once it starts leaking slowly out of an institution, it's incredibly hard to pour back in. The Supreme Court is especially vulnerable to this because the court does not have the normal tools of political power. Congress controls the money, the president controls the executive branch, governors have state agencies, police departments have officers, the military has weapons. The Supreme Court has opinions. That's it. Words on paper. Very important words, yes. Words that can change people's lives, absolutely. But still just words. A court depends on the rest of the country accepting that those words carry authority. And for much of American history, even when people hated particular Supreme Court decisions, there was still a broad sense that the court itself occupied a special place. Not always, not universally, not perfectly, but broadly. The court was seen by many Americans as something different from Congress, something different from the presidency, something a little more removed from, like daily political combat. That idea has been badly damaged. And some of that damage comes from the confirmation wars. Because before justice ever rules on a case, the country now watches them go through a political furnace. And that didn't happen by accident. Supreme Court nominations have always involved politics. I mean, we can't romanticize the past into some, sepia-toned civics poster. But, politics have always been there. But over the last several decades, nominations have become outright ideological warfare. Robert Bork's nomination in the 1980s became a major turning point. Bork was a deeply, deeply conservative legal thinker nominated by Ronald Reagan, and Democrats opposed him aggressively. To conservatives, that fight became evidence that Democrats would destroy a qualified nominee for ideological reasons. However, to liberals, it was a successful effort to stop someone whose views they believed were dangerously outside the mainstream. Then came Clarence Thomas. His confirmation hearings in 1991 were nothing short of explosive, especially after Anita Hill accused him of sexual harassment. The hearings became a national trauma over race and gender and power and harassment and credibility. And Thomas was confirmed by a narrow margin, but the process left deep scars. And then there's Merrick Garland. In 2016, Justice Antonin Scalia died during President Obama's final year in office. Obama nominated Garland, who was widely viewed as a moderate. Senate Republicans refused to hold a hearing or vote, arguing that the vacancy should be filled after the presidential election. And then, of course, Donald Trump won and Neil Gorsuch got the seat. And for many Democrats, that was not just hardball politics. That was theft dressed up as procedure. Then in 2020, after Justice Ruth Bader Ginsburg died, weeks before the presidential election, Republicans quickly moved to confirm Amy Coney Barrett. The same party that had said in 2016 that voters should decide who fills a Supreme Court vacancy in an election year suddenly discovered that calendars are very mysterious things. And yes, conservatives had an argument. They said the Senate and the presidency were controlled by the same party in 2020, unlike 2016. Fine. Yeah, I mean, that's the argument. But politically, to millions of Americans, the message was simpler. Do as I say, not as I do. And that sequence did lasting damage, because when the public watches one party block a nominee for nearly a year, then rush another nominee through right before an election, it becomes harder to sell the idea that the court is untouched by politics. Again, I mean, that doesn't mean every ruling is partisan. It does not mean justices are simply, party operatives, but perception matters. And perception has gotten really, really ugly. And then we have the ethics controversies. We'll jump back to Clarence Thomas here for a moment, because he's faced major, detailed reporting about luxury travel, gifts, financial connections involving wealthy conservative donors. The issue is not only whether every specific action violated a particular rule. I mean, that matters, of course. The larger issue is, what does that do to public trust? Because when regular Americans hear that a justice accepted lavish trips or gifts from billionaires, they don't sit down and say, well, let me carefully examine the disclosure framework and statutory thresholds. What they normally say is, are you friggin' kidding me? And honestly, that reaction is reasonable, because the court asked the public to accept its decisions as principled, independent, and legitimate. That becomes much harder when justices appear to be moving in elite political and financial circles with people who clearly care about the direction of the law. Even if a justice insists that no vote was influenced, even if there is no, direct quid pro quo, even if defenders argue that criticism is exaggerated or partisan, the appearance matters. The court survives on trust. And I would argue personally that a justice who cares about the court, when there's that much shadow casted on a judge's reputation and a judge's, fairness, or a judge's motives, I think a justice who cares about the court would resign to protect the court that they claim to want us to value above most other things. But that's just me. But anyway, yes, a court survives on trust, and trust does not require a criminal indictment to be damaged. It can be damaged by the sense that people making the decisions about everyone else's rights are living by rules that are very different from the rules that the rest of us have to follow. That is the ethics problem. But there's another problem that might even be bigger, and that's the who appointed them problem. More and more Americans look at the Supreme Court decisions and immediately sort the justices by president. Trump appointee, Obama appointee, Bush, Clinton, Biden. And once that becomes the lens, the ruling itself becomes suspect before anyone even reads it. People don't ask, what was the constitutional reasoning? They want to know who appointed the judges in the majority. And I think that that's very dangerous for the court. And if I'm being clear, the picture isn't always simple. There are unanimous decisions. There are cross-ideological coalitions. Conservative justices sometimes split from other conservatives, and liberal justices sometimes join the conservatives. The court is not literally Congress with robes and better acoustics. It's different, but the broad pattern is hard to ignore, especially in like the biggest culture war cases, powers of government cases, rights cases. People increasingly expect the outcome based on the lineup. And when people can predict outcomes based on appointment history, the court starts looking less like an independent legal institution, more like, a delayed result of a presidential election. That is a legitimacy problem. Because for many Americans, the question isn't anymore, what does this justice believe the Constitution requires? It's just simply, who put them there? And once that question dominates, every decision gets filtered through partisan suspicion. If a conservative majority limits federal agency power, progressives see it as a conservative project. If a liberal bloc dissents on a civil rights case, the conservatives see it as liberal activism. If the court sides with a president from one party, the other party assumes the fix was in. Every ruling becomes another entry in the national scorecard. The red team got this one. Blue team got that one. That is not healthy for a court whose authority depends on the idea that law is something more than politics by another route. And Dobbs poured gasoline on that perception because for decades, conservatives worked to overturn Roe. Republican presidents promised judges who would change the court. Conservative, and that part right there, when conservative politicians were coming out and saying, we're going to appoint judges that will overturn Roe. How do you listen to that and not think that the court is political? But anyway, Senate battles were fought over the future of abortion rights, and then Trump appointed 3 justices and Roe fell. Now, conservatives will say yes, because Roe was wrongly decided and Dobbs corrected the constitutional error. And progressives say, come on, man, we watched the machine being built. And then we watched it do exactly what it was built to do. That divide isn't going away. And this is where the court faces deeper problems than criticism. They always have. The problem is when criticism becomes disbelief, when people no longer believe the institution is acting in good faith, when the robe no longer separates the justice from the political project, when every opinion sounds to half the country like a legal memo written backward instead of from the desired result. That's when legitimacy starts to crack. And once it cracks, it does not only hurt the cases the people already care about, it affects everything. If people believe the court is political when it rules on abortion, they may also suspect politics when it rules on voting rights. If they believe the court is political when it talks about presidential power, it may suspect politics when it rules on religious liberty. That suspicion doesn't stay static. It spreads. It stains the entire institution. And maybe the most frustrating part is that there is no easy way to fix it. You can't fix it with one ethics code press release. You can't fix it with some unanimous opinion on some subject. You can't fix it with one justice giving a speech about civility at a law school dinner where everyone, eats chicken and pretends there's nothing wrong. This is bigger than messaging. The court has to be trusted as a court, not as a prize, not as a weapon, not as a delayed fuse of the last, presidential election. A court, an institution that applies law in a way the public can at least recognize as principled, even when the public disagrees with the result. And that is a high bar, but it has to be. Because the Supreme Court asked the country to accept its judgment on some of the most explosive questions in American life. Who has rights? Who has power? What can government do and what can it do? What does liberty mean? What does equality require? What does democracy allow? If the public believes those questions are being answered by legal principle, the system can hold even through disagreement. But if the public believes those questions are being answered by partisan politics, the system starts wobbling. And right now, the wobble is not subtle, which matters because June is not over. The drawer is not empty. There are still knives inside. All right, so let's go back to June here, back to the drawer, back to the reason we're having this conversation at all right now. Because the court is not done. As I'm recording this, there are still major cases waiting decisions, and while the legal details vary from case to case, most of them circle around the same themes we've been discussing all through this episode. Power, authority, who gets to decide, and how much power any one institution should have. One of the biggest questions sitting before the court right now involves birthright citizenship. Now, before you start writing that email, the legal fight currently in front of the court is not necessarily a straightforward ruling on whether birthright citizenship itself is constitutional. The immediate dispute is more procedural and involves the power of lower federal courts to issue nationwide injunctions. And I know that sounds about as exciting as reading the owner's manual for a dishwasher. But stay with me, because sometimes the boring legal mechanism is attached to a very big constitutional question. The larger issue lurking behind the case is whether a president can substantially alter how birthright citizenship is applied in the United States. And that's a huge question, because the traditional understanding of the 14th Amendment has been that people born in the United States are citizens of the United States regardless of the immigration status of their parents. That understanding has existed for generations. If that understanding changes, the consequences would not be measured in legal journals. They would be measured in people's lives, people, with families and children, future citizens. And regardless of where somebody lands politically, this is exactly the kind of issue that demonstrates how constitutional interpretation becomes real-world policy. Then there are cases involving executive power. And honestly, if there's a recurring theme of modern American politics, it may be the gradual expansion of presidential authority. Presidents of both parties push boundaries. I've talked about this in prior episodes. Every administration claims certain powers are necessary. Every administration discovers reasons why this particular emergency requires this, particular action. And every administration becomes strangely interested in constitutional limits again the moment the other party is in the White House. Funny how that works. The court increasingly finds itself deciding where those boundaries are. Can a president do this? Can an agency do that? Can Congress delegate this authority? Can courts stop it? Can states challenge it? These aren't merely technical disputes. They are questions about where power resides in American government. And they matter because every power granted to one president eventually belongs to the next president. People often evaluate, executive power through the lens of whether they like the person currently sitting in the Oval Office. And I get that, but it's also naive and dangerous because constitutional powers tend to outlive administrations. The authority you cheer today may belong to somebody you despise tomorrow. Another area where major decisions remain possible involves immigration, and immigration has obviously become one of those issues where almost every argument ends up in court. Border enforcement, detention policies, deportation procedures, federal versus state authority. As Congress has repeatedly failed to produce comprehensive immigration reform, I'll say that again because I wanna. Congress has repeatedly failed to produce comprehensive immigration reform, so now courts have increasingly become the place where major disputes have to be resolved. And, that's a pattern that we've been talking about all through this episode. Political institutions avoid difficult questions, and then the courts inherit them. The result is that judges increasingly find themselves deciding matters that many Americans believe should have been settled through the laws. Not just because judges sought the role, because someone eventually has to answer the question. Then there are cases involving religious liberty. These cases often generate enormous controversy because they force courts to navigate competing constitutional principles. Religious freedom versus equal protection. Government neutrality versus free expression. And the challenge is that Americans generally support religious liberty until two competing rights collide. Then things get complicated. Can a person decline certain services based on religious beliefs? Can government require compliance with laws that conflict with those beliefs? Where does accommodation end and discrimination begin? And reasonable people disagree. The court is often asked to draw those lines. And every time it does, somebody walks away convinced the Constitution was protected, while somebody else walks away convinced that it was undermined. That's the nature of these disputes. Finally, there are continuing questions involving voting rights. You knew this one was coming. Questions about who sets election rules, questions about representation, questions about the relationship between states and the federal government, questions that strike at the heart of democratic participation. Not small issues. These are foundational issues, and that is really the point. The specific cases will eventually be decided. The headlines will come and cable news will explode. Politicians will issue statements, carefully designed to become fundraising emails, the next day. Social media will become completely normal and reasonable. Then the news cycle will move on. But the underlying question will remain: how much power should the federal government have? How much power should presidents have? How much power should states have? How should constitutional rights be interpreted? What role should the courts play in resolving political disputes? Those questions aren't going away. The pending cases matter because they help answer those questions. Not permanently, not for all time, but for now. And those answers will shape how power is exercised long after most people forget the names of the individual cases. Which brings us back to the drawer one last time. Because the most important thing I think we've discovered in this episode isn't which knife is inside the drawer. It's why everyone is staring at the drawer in the first place. Every June, Americans gather around that knife drawer. We speculate and we argue and we predict and we brace ourselves. We wonder who's going to win and who's going to lose, whose rights will be expanded, whose rights will be limited, what rules will change, what precedents will survive, what ones won't. And that attention is understandable because Supreme Court decisions matter. They matter enormously. They affect real people living real lives. But after spending all this time talking about individual rulings, individual justices, individual controversies, I keep coming back to something else. The sharpest thing in that drawer may not be any individual decision. It may be the court's legitimacy itself. Because disagreement isn't the danger. Americans have always disagreed. We disagreed about segregation, about criminal justice, about abortion and marriage and religion and voting rights and executive power. Disagreement is part of democracy. It has always been. The danger begins when people stop believing the institution deserves the authority that it uses. Because the Supreme Court ultimately operates on something surprisingly fragile: trust. Not unanimous trust, not blind trust, not permanent trust, just enough trust that when the court speaks, the country accepts that its rulings carry legitimate authority. The court cannot function through force. It cannot send in the Marines. It cannot seize a television network. It can't freeze your bank account. It can't compel you to believe in it. Its power comes from the public's willingness to accept that constitutional disputes should be settled there. That is a remarkable amount of authority resting on a remarkably fragile foundation. And right now, that foundation is under stress. Some Americans see a court courageously restoring constitutional limits. Others see a court pursuing ideological goals under constitutional language. Some see principled interpretation, others see politics. And maybe the most important question facing the court is not whether people agree with its decisions. That's never going to happen. Maybe the real question is whether enough Americans still believe the institution is bigger than the outcomes that they like or dislike. Because once people stop trusting the referee, every call is controversial. Every ruling is suspect. Every decision becomes another battle in an ongoing political pissing match. And every knife looks sharper than the last. The drawer will close again soon. Headlines will fade and arguments will move on to something else. They always do. But next June, the drawer will open again. And we'll be right back here, staring inside, trying to figure out what changes next. All right, everybody. Thank you so much for taking the time to download and listen to this episode of Your Neighbor on the Left. I would love to hear from you. I'd love to hear your thoughts on this subject, on any subject, really. And you can get in touch with the podcast in a number of ways. I'll start with going to the website, neighborontheleft.com. Go to the contacts section and either use a social media platform to send a DM or use the email address and contact that way. Please do. I would love to hear from you. While you're on the website, you can also go to the episodes page and you can listen to or download any episode of the podcast going all the way back to the beginning. Just between you and me, I shudder to think of people listening to some of the first episodes when I was really green, but they're all there, warts and all. And there's also the blog section that I mention every week. The blog section has posts that reflect the things that I talk about in the podcast, but it includes my list of sources. And I would love for everyone to check those out. I'll be back on Friday with an installment of Back Porch Files. So between now and then, stay engaged, stay kind, and have the kind of week you'd wish for others.